All right, it's time to go on the docket with attorney John Patrick Dolan as he breaks down all your legal news.
So good morning to you, John. Thank you for joining us.
Good morning, ladies.
Now today, of course, the big story is Ferguson, Missouri. Yes. And as we've seen, there has been a lot of reaction to the recent announcement. And a lot of the protesters are saying that the officer should have had a trial, and they're very upset about this. So can you break it down for us?
Sure. You can only have a trial. No one in this country can be charged unless there is probable cause to file a complaint or an indictment. And so that's before the trial. Is there enough information to go to trial? In this case, there was an extraordinary grand jury hearing. It went over 3 months, 25 actual days, 70 hours of testimony, and the grand jury, after hearing all this, decided there was not probable cause. So you don't have trials just to have trials. You have trials because there's probable cause to go forward, and it was determined that there was not. And it's a little insulting to the grand jurors that people who really don't understand the legal system say, well, there wasn't any justice, because 12 people listened to all the information that was relevant, and they together said, there's just not enough to put this individual on trial.
It's absolutely absurd, some may say.
Well, I mean, I don't know if it's absurd. You know, there's two sides to every story, but in this case, there was not enough evidence, and when you looked at the actual evidence, the physical evidence, plus the testimony, it was determined by the grand jury, who are citizens who simply come in to do a community service, that there was simply not probable cause.
Now, speaking of the evidence, some people are looking at the photograph of the officer and saying, well, he wasn't really injured, so was he really being threatened by this young man?
Well, he's got some small bruising, but frankly, the physical evidence was that DNA from the victim, Michael Brown, the deceased, was found on the officer's leg, on his collar, inside his car. So who goes in and sticks their hand in and starts to fight with a police officer over their gun and thinks that somehow or other there's not going to be negative consequences? I mean, it's a really bad situation. Something else really important. Everybody keeps saying the officer had to be in fear of his life in order to use deadly force. That's absolutely stone cold wrong. Every state in the union says when somebody is made an officer, when they are qualified to be a law enforcement officer, they have the right and the authority and the need many times to use deadly force to prevent felonies or to apprehend someone who has committed a felony. In this case, the felony was robbery, remember, from the convenience store. It wasn't over, as many of our law students would tell you, because the individual, Michael Brown, hadn't reached a place of safety, and then the officer was attacked. Officers have the authority to use deadly force, and in this case, it was found by the grand jury that deadly force was appropriate. I'm not taking sides on the case, I'm just saying that was a decision that was made.
Talking about the looters, the rioters, there are so many causing such problems, fires, theft. What do you do? How do you try these people?
Well, I mean, there's over 100 arrests, so there'll be trials for those people. I'm sure they're going to look at the video and determine if they can figure out who are the people that were the looters. You keep hearing about prosecutorial discretion recently in the news, and I can tell you that they really used restraint in the number of arrests and restraint in the response on the first night. Apparently the second night, last night, it was a little more aggressive as far as law enforcement is concerned. And you know, I'm a defense lawyer. On the other hand, I have to say, you can't allow people to burn down buildings just because they are unhappy with results. Everyone in a court system, if they're on a particular side, are unhappy sometimes with results. But you don't burn down buildings because you're unhappy with the results, and that's what happened over there.
I absolutely agree with you that obviously looting and all of this chaos is not the answer to this. But it looks like a lot of the residents there seem to have a lot of pent-up frustration or anger, perhaps, from maybe racism that they've experienced in their own lives, and this just kind of brought everything to the surface. Would you agree with that?
I do agree with that, and there's certainly two sides to the story, and I'm sure there are people who feel that law enforcement is oppressive toward them, and obviously this is a black-white situation, but frankly, there's ways to express your frustration that come short of violence and arson. And, people do get frustrated, and I'm sure that will be taken into consideration as these cases are prosecuted. But we shouldn't stand for people acting in a lawless, violent manner just because they're frustrated about the judicial system.
That's right. There have been a lot of peaceful protests in a lot of cities, including here, San Diego, Los Angeles. So
and citizens have every right. Citizens have every right to do that.
Let's move on to Malcolm Patterson, the man who is now hospitalized. Is that the reason he hasn't been making his appearances?
Well, that seems to be the report, and frankly, certainly understandable. An 84-year-old man, if he's hospitalized, is not in any condition to go to court. It is regrettable that that wasn't known and presented to the court when the court doubled his bail and issued a warrant for his arrest, because frankly, I think Judge Wells is a reasonable person, and if there was information that the individual, Mr. Patterson, was in the hospital, he probably wouldn't have raised a bail and probably wouldn't have issued the warrant. But the reason we found out is because law enforcement went to Mr. Patterson's home and was informed that the day before the court appearance date, he was in the hospital. So it's just too bad that that information wasn't presented to the court, because it makes us all look a little strange in the judicial
how did the
system.
attorney not know?
Well, maybe there just wasn't communication. I mean, that's all I can, speculate.
And of course, Patterson is the elderly man who drove into a school fence, and then a young boy had his leg hit and then had to be amputated.
Right.
Has his attorney stated a reason as to why he ran into that fence?
Well, I think that's the subject of the case that's before the court. Was it because he was elderly? Was it because it was just an accident? Was it because he was under the influence of alcohol? Those are questions of fact that still have to be determined.
It wasn't proven that he was under the influence of alcohol?
Well, there hasn't been any hearing to prove that yet.
Okay.
I mean, it's alleged that
It's
he was under
alleged,
the
yeah.
influence, but there has not been any facts presented yet.
Okay, thanks, John.
Indeed.
Great information. Really appreciate all that.
All right, ladies.
Thank you very much.
Happy Thanksgiving.
Yeah,
Happy
enjoy yours.
Thanksgiving to you, yes. And here's John Patrick Dolan's information. Of course, you bring up Thanksgiving. Good reminder not to drink and drive, because this is one weekend you probably don't want to have to call John Patrick Dolan, right?
That's right. Although the phone will be available.
Yes, thank you, John.
DolanLawOffices.com is John Patrick Dolan's information if you have any legal questions for him. And reminder to stay safe this holiday weekend.
All right, stay with us. We'll be right